I'm Bridget Stomberg.
And I'm Lisa DeSimone.
And this is Taxes for the Masses.
Today's episode is on a recent change to how the IRS views the endorsement of political candidates by qualified tax-exempt organizations.
In July of 2025, the IRS agreed to a legal judgment that significantly reinterprets a long-standing law that prevents churches and other tax-exempt charitable organizations from endorsing political candidates. In today's episode, we welcome Ben Leff, a law professor at American University, to discuss how this change came about and its potential implications.
Hello, B.
Hello, Lisa.
Today, we're talking about the Johnson Amendment.
And I'm not going to lie, I definitely needed some help with that one.
I did too. And I kind of expect many of our listeners might need a little help. So it's a good thing we're here.
Yeah. So to be clear, Johnson as in LBJ.
Yep. From the great state of Texas.
Yeah. Before we researched this episode, pretty much that's what I knew about him is that he was from Texas.
Great.
And
good.
I have some memory that, did we take a class in the PhD program that was in a building named after him somewhere?
Yeah, because his presidential library is on campus at the University of Texas. And if I'm not mistaken, it was the first presidential library to be situated on a university campus. And yeah, we were in a building that was like right next door to the presidential library.
Okay. Yeah. All right. Very good. I just remember many nights walking across campus to get to that class.
I think the public affairs school is named after him. Yeah.
Yes. Okay. Good. That's tracking. So we have now exhausted my knowledge of LBJ. And what do you got to say about the Johnson Amendment?
Well, it dates back to 1954, and it prevents churches and any other tax-exempt charitable group from endorsing political candidates. It's named the Johnson Amendment because it was inserted into a tax bill by then Senator Lyndon B. Johnson, way before he was president, or vice president for that matter.
For many years, the law was seen by some as appropriate.
Yeah.
Right? Let's set up a wall between charities and politics.
Church and state?
State, maybe. I'm on board with that.
Yep.
Okay. But conservative Christian activists and some independent legal scholars viewed it as a clear violation of the First Amendment and basically everybody's right to free speech, which I think we still have.
Maybe.
Maybe. So they've been trying to challenge these restrictions for more than 15 years.
Yep. And we've seen some real world conflicts that are driving this challenge. So one example, Robert Jeffress, the pastor of First Baptist Dallas, revealed that his church faced an IRS inquiry into its tax-exempt status after hosting a rally with political figures. Franklin Graham runs a large ministry. He also faced similar IRS inquiries during the tenure of President Barack Obama. And this mounting pressure campaign led Jeffress's church to send a 7-page letter to the White House Faith Office outlining what they called, quote, wrongful weaponization of the law and another, quote, unlawful targeting of our church.
And this is where the First Amendment argument comes in. So the core grievance, according to these activists, is that the government shouldn't regulate what can be said inside a house of worship. So what a preacher or a pastor can say from the pulpit.
Yep.
So Jeffress said, quote, what a pastor says in a church service is none of the government's you-know-what business.
Oh,
Fair.
Okay. Yep. I like the you-know-what. Mm-hmm.
You know what? Okay, so despite trying several strategies over the years, including a planned campaign starting in 2008 to basically provoke the IRS into a legal confrontation, which is not super mature.
No.
The IRS stayed calm, and they, for the most part, didn't take the bait. So this didn't really bubble up to become a huge issue.
So these groups returned to a strategy focused on the courts. This led to a lawsuit filed by the National Religious Broadcasters and 2 Texas churches with the goal of getting the case before the now conservative majority Supreme Court, and conservative Christians scored a major victory. The IRS reinterpreted the ban via a legal settlement, stating that the Johnson Amendment should not affect, quote, communications from a house of worship to its congregation in connection with religious services through its usual channels of communication on matters of faith, end quote.
So we got to remember churches, tax-exempt organizations, they're 501c3PO organizations. And
Thank you.
One of the things that they can't do is engage in political endorsements, right?
Yes.
And so what's at stake here is that these churches could lose their tax exempt status if they get into the business of campaigning.
Yep.
So the critical takeaway from this statement is that the IRS is basically now essentially saying for the first time ever that actually churches can endorse political candidates, but from the pulpit. So like inside the house of worship. And the IRS likened these permitted communications to a private conversation among family members. It all sounds potentially harmless, but the single change functionally nullifies a core tenet of the law just for houses of worship.
Yep.
And this decision or this interpretation that the IRS has come up with is considered the most significant victory for church political organizing in 70 years, essentially since the Johnson Amendment was passed.
Yeah, it's a big victory, but it's one that has massive implications and a lot of questions remaining about how this should be implemented and whether it should be implemented.
Correct.
So the change is pretty narrow in that it only applies to those religious houses of worship, like you said.
Yep.
It does not apply to other tax-exempt nonprofits like charities and cough universities.
Nope.
The IRS achieved this outcome through a settlement in a Texas court, and it wasn't just the IRS involved, it was the Department of Justice too. So we've got like a lot of government cooks in the kitchen here. It was not through issuing formal regulatory guidance, which is the way we would normally see it done, or through, I don't know, Congress actually writing the law in a different way. Just throwing thoughts out here, but like, you know, as we've said multiple times on the pod, Congress writes the law, not the IRS.
Exactly. And so because of what you just said, some experts have called this the path that we took to get here, quote, awkward and misguided.
Oh, good. Mm-hmm.
Which I think might be the new IRS tagline. Or maybe the new government tagline. Unclear.
Yes.
But the ultimate goal for activists is still total elimination of the Johnson Amendment, which is likely going to require either a congressional modification or a Supreme Court victory.
You would think. Yep. So a lot of complexity here, a lot of issues at stake. To help us unpack all this, the law, ambiguity, Constitution, right? We are going to bring on our guest today who recently analyzed how the IRS can protect free speech without creating massive campaign finance loopholes.
That sounds like a great goal.
Yeah. We're delighted to welcome to the podcast Benjamin Leff, a professor at American University's Washington College of Law. He teaches courses on U.S. federal tax law and the law of nonprofit organizations. His scholarship focuses on the regulation of nonprofits. In addition to teaching and writing, he hosted a podcast about teaching the introductory law school tax class called Tax Class. Before becoming a professor, he practiced tax law in Austin, Texas, and clerked in federal district court. He's a graduate of Yale Law School, holds a master's in religious studies from the University of Chicago, and a bachelor's from Oberlin College. Ben, thank you so much for being on the podcast.
Thank you so much for having me. I'm a big fan of the show. I've been listening to it for a long time, and I'm extremely excited to be a guest.
We're excited to have you on.
Very excited to have you. Always like to hear people have been listening for a while.
Yeah.
So we're here to talk today to you. You've done some research and some writing and some analysis in this area. So the first question we wanted to ask focuses on a recent piece you wrote where you argue that although the core idea of protecting political speech is good and correct, and
right.
I think most people would agree with that. I hope
Hopefully.
Hope. That there's maybe some problems with the IRS's current implementation of the change, specifically that it could create loopholes. And we all don't like loopholes when it comes to the IRS. So can you talk a little bit more about the current implementation and the loopholes that it could create?
Sure. And I need to differentiate between two things. One is the way that the IRS has been enforcing this or has been purporting to enforce. In other words, the guidance from the IRS until this recent case, and then what is proposed in the case and what might follow from that. So
Perfect. Thank you.
Prior to this case, the IRS has been very insistent for decades that the Johnson Amendment means that 501c3 organizations cannot engage in in campaign speech, including endorsements. So campaign speech is just like endorsements plus speech that is like an endorsement, evaluating candidates and showing that you support one candidate over the other. And the IRS has been really clear that charities, which includes churches, 501c3 organizations, including churches, can't do that at all. And that includes in a sermon in a church. So a minister in a church under existing IRS guidance could not endorse a candidate or communicate a preference for a candidate. And that's been the longstanding rule. That's kind of the Johnson Amendment. Comes straight out of the statutory language that Congress wrote for the Johnson Amendment. It's kind of the best interpretation of that language. Just this summer, the IRS, it's actually represented by the Department of Justice in a case that includes two churches in Texas. And the churches has argued that that was unconstitutional. And the Department of Justice, on behalf of the IRS, proposed a rule that said, we're reversing ourselves. In the case of internal communications in houses of worship, a communication can endorse a candidate. So that's kind of the new rule. And it's only been proposed. The judge hasn't adopted that rule, hasn't issued an order. And in fact, the judge set a date to continue oral argument on it, and including some other parties other than the government and the plaintiffs on November 7th. So coming up very soon in Washington, D.C. So that interpretation is still a work in progress. The reason that I said in my op-ed that the interpretation would open the door for a kind of big loophole in campaign spending is because this concept of internal communications is not well defined in the order. And kind of the question is, what is the next step? Once this order is out there, the IRS has signaled that it's going to accept certain kinds of communications, internal communications of a house of worship. So what are people going to do, and what is the IRS going to do to respond to that? How is it going to enforce that line of internal communications? And the fear is that kind of two levels of interpretation that could spread. One is that churches already have massive online worship services.
Sure. Yeah.
So there's some churches, like if I go to my synagogue, the rabbi says stuff and like we're all sitting in the room together. But then that gets published and that gets spread and gets discussed. But some churches also just have these vast networks of members who are participating in worship. So that would be explicitly within the limitation as the way the IRS described it. And then there's a question, and then how might churches expand that? So imagine you have a sermon. If the church's regular practice is to send out that sermon, imagine that its regular practice is to pay $15 million to take out a Super Bowl ad where it shares its sermon. If it shares excerpt that says vote for Donald Trump and it spends $15 million on that, well, that's $15 million of tax deductible funds. That seems like over the line. But how is the IRS going to figure out what that line is? What's the enforcement going to be, et cetera?
That's interesting. So there's another line at stake here, which is that this current proposal only allows houses of worship to endorse candidates. And you argue, I think very reasonably, that this is effectively discriminating against secular organizations, not non-churches, in the regulation of political speech. So why do you think we should expand it, given the previous concerns you just had about it being maybe a little too expansive with these loopholes? What are the risks of expanding or not expanding?
Absolutely. So first, let me just caveat this by saying I'm a tax professor, not a constitutional law professor. So the first question, which I actually think is about cost-sharing accounting, like I honestly think that the fundamental question is about cost-sharing accounting, which is like a hard topic. And that's like very much within my area of expertise. Constitutional law really kind of formally isn't, though I have strong opinions about it. So this is a constitutional law argument, and it's highly contested. I think that a core speech rule like this couldn't be reserved only for houses of worship. And the main thing is whether my constitutional argument that it couldn't be is correct or not. On the ground, the first question is, how are parties going to try and expand the rule? And I think it's inevitable that secular organizations are going to take this rule, apply it to themselves, and say that the limitation to houses of worship is unconstitutional. And the question, well, what will the IRS do then? Will they vigorously pursue the limitation to houses of worship and get it all the way up to a court that can make a definitive ruling on that, which ultimately is the Supreme Court? Or will they kind of let it slide and there'll be a lot of expansion? That's the question that I think is important. And there's already a case that I've written on called Safe Space, which is a secular organization which raises this very issue. I assume that they'll be pursuing it. So I agree that it's going to expand the loophole to move beyond churches. I just think that that's inevitably what's going to happen, unless and until the IRS successfully makes the constitutional argument that it is permitted to limit this rule only to churches. And I think it's going to lose that argument eventually.
So you alluded to this in your answer to the first question, but can you talk a little bit about the process here? What's happening from a procedural standpoint? Because it does feel a little strange that this is coming out of, like you said, a court case in Texas with just 2 churches involved. For our listeners, we talk a lot about Congress setting tax policy. Congress sets other laws too. This Johnson Amendment, as you said, Congress wrote the statute that we're talking about here. So shouldn't they be the ones to change it or fix it if they see an error? Why is this making its way through the IRS through one single court case?
Yeah, that's such a great question. And one of the things that is so great about that question is there's Congress who writes the law and has an extremely large amount of leeway in how they write the law. Obviously, the Constitution constrains them ultimately, and this is a question where Congress wrote the law one way, and then the United States Supreme Court in 1983 said that you have to interpret a similar law in a particular way in order to make it constitutional. So that's kind of what creates the problem. Congress could write the law, rewrite the law, and there's a very compelling argument that they should. And there's legislation that has been proposed. It's proposed in the current Congress, and it's been proposed over and over and over again, called the Free Speech Fairness Act. And the Free Speech Fairness Act attempts to do exactly that, to rewrite the law in order to create a kind of loophole. My personal view about the Free Speech Fairness Act is that it is too permissive of 501c3 money being used for speech. So it creates too big a loophole. But like this settlement that the IRS has agreed to, it's the congressional version, it's the statutory version of this same claim. And the fact that I think it's too loose, Congress could disagree with me. Free Speech Fairness Act has a bunch of Republican co-signatories. I think it has 0 Democrats. So the question about the Free Speech Fairness Act has been sitting in Congress for over a decade, over and over again, reintroduced by Republicans, never supported by Democrats. So where is that going? But also, there's the IRS regulatory approach, which, as you know, and your listeners may know, the Treasury Department writes regulations for tax administration, and the IRS can write non-regulatory guidance, usually in the form of a revenue ruling or something like that. And so there's a way in which the IRS could write much more explicit guidance in a much more stakeholder inclusive way through either a revenue ruling or a regulation, a true regulation from the Treasury. And the big thing that happened is that the IRS has this, or the Treasury Department has this thing called their priority guidance plan, which every year they issue this list of guidance that they're going to work on. And for the first time, the Johnson Amendment was on this list. So the Treasury Department has signaled, or the IRS has signaled, that they're going to think about this in a regulatory way. And one of the things that, I've been kind of screaming for 15 years that the IRS should write regulations to better describe this. And they've signaled that at least they're going to start to think about how to try doing that. And then there's this third option, which is what's actually happening, which is it's not even IRS lawyers, it's the Department of Justice lawyers in a case in district court have agreed to a settlement that radically reverses what the IRS is currently saying is their position in their existing guidance. And that's a very awkward place to land. Maybe it's when you think about just the institutional dynamics of how much influence the Trump administration has over various branches of government and stuff like that, it might be that was the first mover. But it's a bad place for it to land in a court case that relates to a single set of plaintiffs.
Absolutely.
I think one of the core issues here that I want to make sure our listeners understand that this isn't just about free speech. There's a tax component to this because a 501c3 entity like these churches are tax exempt entities, and making a contribution to them is a tax deduction for the person making the contribution. And so if these entities can now start endorsing political candidates, we're now allowing tax deductions for funding of these endorsements.
That's exactly right.
And we currently don't allow tax deductions for political campaign contributions. So essentially what we could be doing is circumventing and getting a deduction for ultimately making a political campaign contribution.
Yep, that's exactly right. The reason that this is a problem is because it's a free speech doctrine, like a train hitting head on a tax doctrine, which is what can you take tax deductible contributions for and what can you not take tax deductible contributions for. And one of the things that sometimes people aren't really aware of about tax deductions is, though your listeners, I hope, have heard you say it enough times that it is true, that a tax deduction for charitable contributions is an itemized deduction, which means that it has no effect on 90% of taxpayers. Only itemizers get that effect. And it's not exactly true, but itemizers are about the top 10%, the wealthiest 10%, or the highest income 10%. Not exactly, but close. Yeah. And then even within them, the difference between someone who has a 35% marginal rate and someone who has a 10% marginal rate is very dramatic. Because when you get an itemized deduction, if you're at a 35% marginal rate, you get 35 cents to every dollar that you donate.
Yeah. Preach.
If you're at a 10%, then you get 10 cents. So it dramatically magnifies the buying power of the wealthiest Americans. And that's without even mentioning that if you contribute appreciated stock to charity, then you avoid all of the capital gains tax. Plus, in addition to that, you get the deduction at your highest marginal rate. So it's like a really magical thing for very wealthy people, and it's an entirely trivial thing for almost everyone else in the world. And if you think about the relation to that and campaigns, political campaigns, that is not a good policy. That's messed up.
No, and to bring it full circle, as only a nerdy tax professor would do, we've basically sort of backed our way into a conversion strategy, right? If you're giving, you want to give money to a political campaign that's not tax favored, this is a way for you to convert that. You're still getting what you want, which is that say in the political race, but you're doing it kind of in a circumventing, not intended, icky feeling way.
Yeah.
That's
now,
my
in defense,
for it.
Right. In defense of the kind of the position that is largely the conservative position, sometimes conservatives will say, we want to get rid of the Johnson Amendment. Trump has said that over and over and over and over again. We want to smash the Johnson Amendment, get rid of the Johnson Amendment. No one who thinks about it actually thinks that. Everybody agrees that permitting charities just to launder money for political campaigns is a bad idea. There's not a constituency for that. So that's why there's so much pressure on these limitations that we started by talking about. What are the limitations that the IRS is trying to put in? They're trying to prevent turning charities into money laundering machines for political campaigns. But everybody's trying to do that. And the question is, how do you do that when you also have this free speech doctrine that is messing with the status quo?
Wow. It's very complicated and very interesting, and I'm just happy that tax found its way in there a little bit.
Exactly.
And I really appreciate you coming on the podcast to explain all of this to us. And I like your language. It's a money laundering scheme for political contributions via churches. I think it sums it up pretty succinctly.
Thank you. Yeah. This has been a real central theme in my scholarly thinking for a really long time. And it's very exciting for there to be things to be happening that allow me to kind of try and bring it to a larger audience. So I really, really appreciate that.
A very positive spin on things.
Yeah. Thanks so much for coming on.
Thanks. I really am a big fan of your show. I love listening to it. And
we appreciate it.
It's a pleasure to be on it. Thanks.
So it's time for the good, the bad, and the ugly. And I think the best thing in this situation is that Ben is a fan of the podcast, and he reached out to us offering his expertise on a very recent hot topic, and offering to be on the pod.
Yes to all of that. And sometimes listeners, we get requests for guests to be on the podcast, and it's like, how can you screw the IRS out of taxes, and how can you avoid taxes? And we're like, that's not really. By
the way, usually the answer is to pay the guest money, right, for their advice and services. So they're just like looking to market themselves, which is not our thing.
Not interested in that. But when Ben brought up this particular topic and pointed us to his op-ed, it was something I didn't know about, and I think it's really interesting. I think it's fascinating. So I was very pleased that he was reaching out to present on something that's timely, approachable, understandable, and really important.
Super important. And I think you're totally right. It would have slipped through our radar without him bringing it to our attention.
So if we abstract away from Ben being a great guest, I think, and we talk about the content of the episode, the good outcome is that, we're trying to protect and expand free speech and protected speech. And that's a good thing, right? Many people on both sides, both conservatives and, legal scholars, thought that the Johnson Amendment was a straight violation of the First Amendment.
Yep.
So I think the concept that we're trying to protect free speech is good. I think that's a good thing.
Yeah. I mean, protecting political speech or free speech is a central liberal principle. And I'm using liberal in the classical sense of, without government interference, right?
Yes.
I'm not talking about left-wing liberal ideals here.
Yeah. And just to be clear what you said, because I think you and I try to be balanced, I don't want churches telling the government what to do. So then I have to be okay with the government not telling churches what to do, right? It goes both ways.
Yeah.
And so this is really targeting this idea of governments not being able to tell religious leaders what they can and cannot say during a sermon. Mm-hmm. This is something that Congress should probably be taking up, and Ben kind of alluded to this in the last response to his question. It's been sitting there for a while, and he basically said there's no Democratic support for the bill, which means it's likely not going to get passed. I'd like to think that this is something that we could get together on and come up with something reasonable through bipartisan channels, because if we don't do that, we're probably going to wind up with something that's possibly unreasonable and arrived at through these very convoluted, I don't even want to call them processes, because it's not how it's supposed to happen.
It's going to end up being awkward and misguided, to go back to that language that we had before. Yes.
So procedurally, this is a mess.
It's a total mess. Yes. This shouldn't be happening as a consequence of a settlement by the Department of Justice in a court case.
No, in the state of Texas. I mean, come on.
Hey, settle down there.
Yeah. So first, procedurally, this is a mess. Second, as we talked about, the scope of this proposed change is way too narrow. It applies only to houses of worship, whereas the Johnson Amendment applies to all charities, including hospitals, universities. And so if we limit the change only to religious houses of worship, that basically just feels like discrimination.
Yes, straight up. Yep.
So thumbs down, thumbs down.
Thumbs down. Yeah, and all of these policies, I would say the original implementation of the Johnson Amendment, as well as the current new the new proposed policy, they're too vague. Ben pointed out that they was too vague to begin with, and it's too vague now with, like, as you said, like, what does it mean to be inside if you're broadcasting, live streaming this to millions of people? Like, we need clearer definitions here, or we just need to toss the whole thing out.
Okay, so it feels like we're dipping into ugly territory.
Yeah. Mm-hmm. I have to say, I don't love the idea of giving wealthy taxpayers tax deductions for funding political campaigns.
Yeah.
If we want churches to stay out of government business, we want government to stay out of church business, and we want free speech, but, like, what is the solution other than to get rid of tax-exempt organizations, or at least tax deductions for these organizations?
And then we have to back up a step further, because you pointed this out during the episode. It's not just the tax deduction. It's also the fact that these organizations are tax exempt.
Yeah.
So are we just doing away with the whole thing and everybody pays tax and nobody gets charitable contributions? Like, what is the balance? Because I agree with you. I think this is fascinating.
Yeah.
And yeah, I don't like the idea that the government can tell you what you can and cannot say as a church, but I also don't want to see houses of worship become political action committees that, as Ben said, basically are just going to follow the will of the wealthiest 5-10% of individuals. That's not a good outcome either. I don't know.
So you have to change the disparity between, a contribution to this house of worship, which can be a political voice, and a contribution to a different 501 type of entity that you don't get a deduction for because they are explicitly allowed to, or at least, up until this point, they were the only ones who were explicitly allowed to make these political statements. So I think you have to treat them the same. So we could keep them tax exempt, but you don't get a deduction for contributing to them. I think you have to get rid of that.
And I don't have the numbers on this, so I don't want to go too far down this road, but I don't think that the reduction in the charitable contributions, like, I know it has an impact, but I don't know how big of an impact it has. Like, I think people would still give to organizations. I think people still do give. I still give to charities, even though I don't get a tax deduction for it.
Right. Exactly. Yes.
Yes. So I think it would cut down on charitable contributions somewhat, and I'd like to know how much that is. But yeah, I agree with you that let's just get rid of it, and let's just say that they can be tax-exempt organizations, which is still tax favored.
Yeah, exactly. They're still not paying taxes.
You're still getting a benefit.
Yes.
But we're just not giving individuals a way to circumvent the rules to get a deduction for campaigning.
Yep.
Go write it up.
I'll get right on that.
Draft it up. Send it to your congressman.
I'm sure they'll listen to me. Well, that's all we have time for today.
Be sure to join us for more tax nerdery on future episodes of Taxes for the Masses.